All right, everyone. Thank you so much for staying through this closing keynote conversation. I'm Tom Ginsburg from the University of Chicago Law School, and we are delighted to have Wesley Wong, the Solicitor General of Hong Kong, with us. Hong Kong is kind of an amazing experiment in the rule of law, or has been for the last 20 years, in that it is a rule of law jurisdiction by all accounts. Looking at this index, in the WJP index, it ranks above my own jurisdiction, the United States, so it's one of the top rule of law jurisdictions in the world. Of course, it's in a larger country, which is not in the top ranks of the rule of law jurisdictions. It's in the bottom third, let's say. And that's a remarkable story. And so we're so fortunate to have Solicitor General Wong to talk to us about the challenges that Hong Kong faces and also the successes, how they've been able to maintain this in the 20th anniversary of the handover. So thank you very much, Solicitor General Wong. Thanks for joining us.
Yes, thank you, Professor Ginsburg. Ladies and gentlemen, it is in fact my great honor to be here joining this premier international event, which has brought together such a distinguished group of global and community leaders and rule of law advocates. Since it was founded in 2006, the World Justice Project has made great efforts in advancing the rule of law worldwide through its useful research and global network. The rule of law is not only an important core value for Hong Kong, but also the cornerstone of its success. The Department of Justice of the Hong Kong Special Administrative Region, or in short we call it the Hong Kong SAR, is thankful for this opportunity to participate in the World Justice Forum and meet influencers like you. I wish to say something about the rule of law generally to start with. The idea lying behind the rule of law has been traced back to Aristotle, who reckoned, quote, "It's better for law to rule than one of the citizens, and so even the guardians of the laws are obeying the law." It has often been said, however, that it was not until Professor Dicey of the English University, Oxford, used the expression "the rule of law" in the authoritative text published in 1885, an introduction to the study of the law of the Constitution, that the expression was finally coined, and the ideas generally associated with the rule of law enjoyed a currency they had never enjoyed before. So as human society has become more developed and hence more complex, the interests of individual sectors of it may easily clash. And the rule of law is the ultimate institution for protecting and balancing these conflicting interests. And in places with better education and free flow of information, especially given the popular use of social media and the internet, members of the public are now more aware of their rights and find it easier to discuss law-related topics, even actively, with those whom they otherwise would not have been able to reach. So at times, such discussions are highly politically charged, leading to sometimes polarized conclusions. So in Hong Kong, as in the case elsewhere, where the rule of law as an expression is sometimes chanted by some, as no more than a slogan to advance their own political causes, it is hence more important now than ever to foster, in our view, a proper understanding of the concept of the rule of law. Media reports and other materials in wide circulation, which do not go unnoticed, have from time to time sought to raise alarm about the rule of law position in Hong Kong. Of course, the World Justice Project has conducted a rule of law index, and of course it has tracked Hong Kong's performance in a different light. However, I wish to say that rather than acting on hunches and surmises, an evaluation of the objective evidence, I dare to suggest, is a far more reliable method to find out what is really happening, and it often points one to a very different direction. In this connection, one of the clearest, most authoritative contemporary explanations of the concept of the rule of law was offered by Thomas Bingham and set out in his seminal work, The Rule of Law, of which I'm sure you'll be very familiar with. And in that important publication, Lord Bingham identified 8 key elements or sub-rules of the rule of law. For present purposes, I wish to focus on three of them, and they are the accessibility of the law, human rights, and fair trial. In his own words, and I quote, "The law must be accessible and so far as possible intelligible, clear, and predictable. The law must afford adequate protection of fundamental human rights, and adjudicative procedures provided by the state should be fair." So these elements, among others, are part and parcel of Hong Kong's legal system. And I wish to start with accessibility of the law. I shall first turn to this point, which is actually ingrained in Hong Kong's constitutional jurisprudence. And I shall start with the Basic Law, which sets out the constitutional framework for the Hong Kong SAR as, and I quote the text of the relevant provision, "Local administrative region of the People's Republic of China, which shall enjoy a high degree of autonomy and come directly under the central people's government." And this is itself the embodiment of the principle of one country, two systems through its enactment as a national law. While we have just celebrated, as Professor Ginsburg has mentioned, the 20th anniversary of the establishment of the Hong Kong SAR, we commemorated the 25th anniversary of the promulgation of the Basic Law 2 years ago in 2015. In other words, the people of Hong Kong and the rest of the world were given more than 7 years lead time when the National People's Congress enacted the Basic Law on the 4th of April 1990 on what to expect upon the resumption of Chinese sovereignty over Hong Kong on the 1st of July 1997. So the Basic Law was in fact the product of almost 5 years' hard work, which started very shortly after the signing of the Sino-British Joint Declaration in 1984 over the question of the future of Hong Kong. The Basic Law not only covers the relationship between the central authorities and the Hong Kong SAR and outlines the Hong Kong SAR's political structure after 1997, it also has dedicated chapters to protect fundamental rights and duties of citizens and residents, to preserve Hong Kong's open and free economic system as we know it, and to maintain the city's capitalist system and way of life, as well as the basic features of its common law system. In practical terms, it means that any restrictions or limitations of fundamental rights and freedoms guaranteed in the Basic Law must be accessible and reasonably foreseeable. What this entails was examined in the leading criminal case of Shum Kwok Share, which upheld the constitutionality of the common law offense of misconduct in public office after the handover. It's a case which has since been widely cited before the superior courts in the rest of the common law world in developing the relevant jurisprudence, and by the English Law Commission exploring ways to codify this common law offense. In this case, the Court of Final Appeal in Hong Kong, the setting up of which I shall elaborate more in a moment, opined that, and I quote, "A law must be adequately accessible in the sense that it gives a person an adequate indication of the law relevant to its situation so that, if need be, with advice, he can regulate his conduct." This is in line with the established jurisprudence enunciated from a long line of authorities, including the European Court of Human Rights decision in Sunday Times and the United Kingdom. And it is also important to note that all the recent judgments of our courts are updated online. It is also another important thing we do, just as the UK Supreme Court does, is that whenever the Court of Final Appeal hands down a judgment, there is also a press summary that is given in both English and Chinese so that we can ensure the accurate reporting of the reasoning behind the judgment, and that also enhances accessibility of the law. And in terms of access to law in Hong Kong, it's also enhanced through the enactment of what we call the Legislation Publication Ordinance. It's a new piece of legislation. The launch of a free website, which we call Hong Kong e-legislation, in February this year, provides for a searchable and reliable electronic database of updated legislation, and legislative provisions so published online in both English and Chinese will progressively be verified so that printed PDF versions marked with the words verified copy will enjoy official legal status. And I encourage you to try using it with your mobile devices. But just before you may do that, I wish to turn next to the comprehensive protection of human rights contained in the Basic Law, which are vigorously and fairly enforced by an independent judiciary. The Basic Law itself provides the rights and freedoms of the people of Hong Kong, and it also guarantees fundamental rights, including speech, press, association, and demonstration. And one important provision is Article 39, which actually ensures the continued application of the two international covenants on human rights, as well as the International Labour Conventions as applied to Hong Kong. And of course, no adjudicative procedure can be fair unless the adjudicator is fair. And therefore, judicial independence is another fundamental aspect of the rule of law, particularly in the protection of fundamental rights and freedoms. And under the Basic Law, there are articles which provide for independent judicial power, including that of final adjudication. There are provisions which preserves the Basic Law and permit courts to refer to precedents from other common law jurisdictions. It also provides for the inapplicability of mainland laws unless included in Annex 3, which has to be satisfied it has to satisfy specific conditions and via specified procedures. The Basic Law also provides for the right to confidential legal advice, access to the courts, choice of lawyers, and the rights to institute legal proceedings in the courts against acts of executive authorities and their personnel. And there are also provisions which provide for the constitutional and structural independence of our judiciary. In particular, Article 82 provides that the power of final adjudication is vested in the Court of Final Appeal, or what we call the CFA. It has acted as the final appellate court of the Hong Kong SAR since the 1st of July 1997, replacing appeals to the Privy Council. It is this court which gave judgment on the test of legal certainty and requirement of accessibility for the common law offence of misconduct in public office I earlier mentioned. And the same Basic Law article, and this is important, also permits the invitation of judges from other common law jurisdictions to sit when adjudicating on cases before it. And over the past 20 years, eminent judges and jurists from the United Kingdom, Australia, and New Zealand have been invited to sit on our CFA. Final appeals of all types of cases, including those raising important constitutional issues or concerning important government policies, have been heard by a panel of 5 judges, which invariably includes 1 overseas judge. And judges of high international standing from overseas common law jurisdictions are appointed to the CFA as non-permanent judges, or what we call overseas NPJs. Examples of serving overseas NPJs include top judges like Lord Hoffman, Lord Millett, and Lord Neuberger from the United Kingdom, as well as Mr. Justice Gleeson, Mr. Justice Gummow, and Mr. Justice Spiegelman from Australia's highest courts. The latest 2 appointments are Mr. Justice French, who has just retired as Chief Justice of the High Court of Australia, and Lord Reid, a serving judge of the UK Supreme Court and a member of the panel of ad hoc judges of the European Court of Human Rights. And Tom, you might wish to learn that there is a judgment which handed down yesterday, and the overseas NPJ is actually Mr. Justice French, who has just been newly appointed. He has just held against the government in a criminal case, which deals with the meaning of who or is not a person who manages what is a regulated a guest house as a licensee. And that is going to be an important decision. And this is his first decision since appointment to the Hong Kong CFA bench. So one asks these questions: would these eminent judges be sitting or willing to sit on our CFA if they do not enjoy judicial independence? Or would these eminent judges remain silent if they felt any form of interference in the discharge of their judicial duties? The answer is more than obvious. The fact that Hong Kong can continue to attract overseas judges of such high reputation to sit on our court speaks for itself. And remember, overseas judges do hear and determine cases in which the Hong Kong SAR government is taken to the courts. So extrajudicial observations made by experienced judges whose independence can hardly be questioned also provide powerful testimony to the rule of law in Hong Kong. In a speech delivered to journalists in Hong Kong on the 26th of August 2014, Lord Neuberger remarked as follows, and I quote, "There has been concern in some quarters in Hong Kong about the possible undermining of judicial independence in the light of the suggestion from a PRC white paper that judges administrate the special administrative region. Well, like many legal issues, the argument is ultimately more about the meaning of a word, and words are slippery things. It may be a somewhat cheap point, but I note that the judicial oath, which I took in common with all Hong Kong judges, included promising to administer justice without fear or favor. In fact, it carries on to say without deceit as well. Mr. Justice Patrick Chan, a former permanent judge of the Court of Final Appeal, who has served under 4 Chief Justices, including the incumbent CJ, made these observations at his farewell sitting in October 2013. And he said this, "There is one thing I wanted to say for a long time to those who will perceive any doubt about the independence of our judiciary. Since 1995, I have been involved in the selection of judges, either as a member of the Judicial Service Commission, or the Judicial Officers Recommendation Commission, or the Judiciary's Internal Selection Committee. I can bear witness to the fact that there has never been any interference from any quarter or any person in the appointment of judges. All my colleagues were appointed on their own merits," unquote. So that people can regulate their conduct on the basis of clear laws and enforceable actionable rights through a fair judicial process is not enough. The administration of justice calls for more than just ticking the right boxes for these 3 identified sub-rules of the rule of law. And therefore, if I can have the opportunity, I wish to also mention the role of the government in advancing the rule of law, if I may. And as another key element of the rule of law identified by Lord Bingham, is the exercise of powers, in that ministers and public officers at all levels must exercise the powers conferred on them in good faith, fairly, for the purpose of which the powers were conferred, without exceeding the limits of such powers and not unreasonably. So in the context of the administration of the criminal justice system, the principle of prosecutorial independence is just as fundamental. Article 63 of the Basic Law, therefore, entrenches this principle by providing that the Department of Justice of the Hong Kong SAR shall control criminal prosecutions, free from any interference. And the Secretary for Justice, being the head of the department, has overall responsibility for the conduct of prosecutions in Hong Kong. And written into our statute in the Criminal Procedure Ordinance, Section 15 says the Secretary for Justice shall not be bound to prosecute an accused person in any case in which he may be of the opinion that the interests of justice do not require his interference. The effect of this provision is to endorse generally accepted and long-standing international practice under the common law, that the decision to prosecute includes 2 required components. A, the admissible evidence available is sufficient to justify instituting or continuing proceedings. And B, the general public interest must require that prosecution is warranted. So on behalf of the community, prosecutors, whether employees of the government or private practitioners to whom cases are briefed out, take on a heavy responsibility to ensure that justice is dispensed with equal measure and in an even-handed manner at all times. When exercising prosecutorial discretion in Hong Kong, they are therefore assisted by a published prosecution code from the Department of Justice, which provide them with a framework of defined and transparent policy guidelines. And this prosecution code is available on the internet for all to see. And more generally, counsel from the Department of Justice carry out the sometimes unenviable and thankless task of advising policy bureaus and government departments, and sometimes to their disappointment on the legality of proposed government legislation and administrative measures. It is, after all, an important principle of the rule of law that the government should not be above the law, and all government action must be within the parameters of the law. And despite all these efforts, judicial review remains in the Hong Kong SAR, like other common law jurisdictions, a robust means to ensure that this principle is upheld. In fact, the legality of the laws passed by the Hong Kong SAR legislature is also subject to constitutional review before the courts. It's therefore fundamental that the adjudication of justiciable rights is not shut out from the court system just because a citizen who wishes to pursue such rights cannot afford the legal fees to be properly represented. This is why an elaborate and comprehensive system of legal aid is another key element of the rule of law in Hong Kong. It means more than just the facilitation of a fair trial process. According to Lord Bingham, quote, means must be provided for resolving without prohibitive costs or inordinate delay bona fide civil disputes which the parties themselves are unable to resolve. In the Hong Kong SAR, we have a healthy legal aid system for both criminal as well as civil cases. Legal aid is available for criminal cases tried in the district court, which may pass a sentence of up to 7 years, and a court of first instance, where even more serious cases are heard, and all criminal appeals. For trials, there is no merits test for cases before either of these courts, and legal aid will be granted as long as the means test is passed. A different but similar system is operated on government subvention through the Duty Lawyer Service to provide legal representation for defendants on trial before the magistrates' courts, the sentencing powers of which is normally limited to a period of 2 years imprisonment. And for civil cases, legal aid does not only cover inter-citizen claims in private law actions and matrimonial causes. As far as public law litigation is concerned, applicants for judicial review would, subject to the applicable means and merits test, be placed in a position to invoke the supervisory jurisdiction of the courts. The legality, constitutionality being one facet of it, of legislation as well as government policy or administrative decisions may be challenged with funding provided by the government. You may wish to know that the latest figures we have, that of the total expenditure of 860.5 million Hong Kong dollars for the 2015 to 2016 financial year, the Legal Aid Department actually spent 452.8 million Hong Kong dollars on civil cases and 115.4 million Hong Kong dollars on criminal cases. The total expenditure in the budget estimates for the 2017 to 2018 financial year is even higher, at 996.8 million Hong Kong dollars, and this is almost 128 million US dollars. And as a matter of fact, people of different, even unpopular political views have been legally aided when they engage in litigation. Incidentally, a growing number of lawyers devoted more and more time to pro bono work complements the government's efforts to enhance access to justice.
Thank you very much, Solicitor General. I want to ask you some questions about some of the issues that I laid out at the outset. I think you presented a wonderful overview of the operations and the a detailed account, really, of the various aspects of the rule of law in Hong Kong. I think the questions which have hit the press are a couple of the things I want to talk to you about. And of course, one of them was a statement by the Chinese president about the Sino-British Joint Declaration of 1984, saying, well, it's just a historical document, no meaning, and such. And so I guess my question for you is, does that change anything on the ground in Hong Kong? Might it in the future? And what does it do to the attitudes of the lawyers and the other members of the legal community?
I'm glad you raised this question. As I've mentioned earlier, in Hong Kong, the constitutional framework and the protection of freedoms and rights are embodied in the Basic Law, which is a national law. I do actually have a copy of it here, and from the way it has worn and torn, I'm reading it very often. What the position in Hong Kong law is this. Like in many common law jurisdictions, having a English law heritage, international treaties do not automatically become part of the domestic law. And this is why it is so important that the principle of one country, two systems is actually implemented through the Basic Law. What the Sino-British Joint Declaration says is this: there is annexed to it Annex 1, which is an elaboration of the principles of one country, two systems, and is written into the Sino-British Joint Declaration that these would be implemented through the Basic Law, which the National People's Congress has done, and the provisions of the Basic Law are actually actionable and justiciable, and people do invoke the Basic Law to pursue their rights or to challenge government actions or the legality of legislation, and they do succeed from time to time. And the latest figures, which just got announced this morning in Hong Kong, is that the total amount of legal aid that has been granted in respect of judicial review challenges brought against the government is something like 36.6 million Hong Kong dollars. That translates to about 1.4 million US dollars, and about 72% of these cases succeeded. And I think the figure shows very well that one who wishes to pursue their rights as guaranteed in a Basic Law to implement the principles of one country, two systems, got pursued through invoking the Basic Law, which is part of the domestic law in Hong Kong, and that is what is going to stay.
So you bring up the Basic Law. It's a kind of unusual system in the sense it's a Chinese statute. It's interpreted by the Court of Final Appeal and the Hong Kong courts, but of course it's ultimately interpreted by the National People's Congress in Beijing. This is a standing committee of the National People's Congress, so it's kind of a legislative oversight. And I know that some of these interpretations that have been handed down have been controversial. There haven't been many, but I know last fall there was a protest over the one involving the oath, the famous young kids who wouldn't say the oath properly, and some concern about that system. So I guess I wonder if I can ask you about how that supervision from Chinese legislature is working and whether you're concerned about the trajectory.
Again, thank you very much for raising this. It gives me the opportunity to explain the ingenuity of the Basic Law and how it seeks to implement the principle of one country, two systems. As I mentioned earlier, the Basic Law is enacted by the National People's Congress, which is the highest legislative authority for the whole country. And it is at the status of a national law. And being a national law, the beauty of it is that it doesn't just bind the Hong Kong SAR or the Hong Kong SAR courts. It actually binds the rest of China. And that is extremely important because it is useful for the implementation of the terms and the principles of the one country, two systems, so that at the national law level, the different organs, state organs of the country would know what law to follow, which includes to allow the high level of autonomy that Hong Kong enjoys, other than matters such as national defense or such as foreign affairs. And that is why Hong Kong is able to enjoy its power and rights to have its own immigration control, have its own Hong Kong dollar currency. We have free flow of capital, protection of property, and have our own customs system, our own tax system. And that is extremely important. But we need to be careful in that, as this is not what I say, this is what the Court of Final Appeal has said, and we have a permanent judge of the Court of Final Appeal, Mr. Justice Fock, as recently as March this year, who mentioned, and I quote, and he said, we do have in Hong Kong a complex interface between the two legal systems, the one in the mainland and the one in Hong Kong. But the Basic Law is a unique and ingenious way in which to marry the two ostensibly incompatible systems. And in that situation, there will invariably have to be friction, especially given the connection between the people in the two places and also the geographical proximity of the two places. But this is precisely the beauty of it. And people do confuse the concept of power of final adjudication and the power of final interpretation. And it is a matter of national law that the Standing Committee of the National People's Congress enjoys this power to interpret the law that the National People's Congress passes. And Sir Anthony Mason, and I do encourage you to read this article from Sir Anthony, who was a non-permanent judge of the Court of Final Appeal, and he has written an article in the Sydney Law Review, and he highlights the importance of this distinction. And it is there to resolve the tension and it forms an ingenious link between the two systems. And it is important, as you mentioned, Tom, the very recent case where the government took two legislators to court to resolve the legal question as to whether the way in which their oath of office were sworn was or was not constitutional. The government advanced its argument before the court, relying on a common law interpretation of Article 104, which deals with the question of making the official oath. At the same time, of course, the Standing Committee of the National People's Congress gave an interpretation which is meant for the whole of the country. What happened was, when the court, which is the court of first instance, eventually handed down its judgment, it made it absolutely clear that the result would have been exactly the same whether or not there had been an interpretation. The legislators took the case to the Court of Appeal. The Court of Appeal has since also handed down its judgment, and it said exactly the same thing, namely that the interpretation arrived at by the court is exactly the same as what the Standing Committee of the National People's Congress have said it should be interpreted. We are waiting to see what the Court of Final Appeal may say. They're trying to seek leave, or what we call permission, to appeal to the Court of Final Appeal, and we'll see what the Court of Final Appeal may say in deciding whether or not leave should be granted to argue the point. So the short answer to that is that it is a beautiful way to make sure that legal issues could be resolved through a method which could bring two apparently incompatible systems together and to make sure it works.
If I can just push you on that one point, and it's a little impolite, but of course, I think what you mentioned that there was an ongoing case and then an interpretation that came from Beijing, and I think that's exactly, and then the result was exactly as it would have been had the Hong Kong courts, been left to their own processes. And I think that's exactly what some of those lawyers were upset about, that there was this kind of intervention. And I guess, do you think that there is a risk of more frequent interpretation, sort of sua sponte interpretation from Beijing?
Well, I think we need to look at the facts and the issues in context. In the past 20 years, there have been 5 interpretations that have been made. One of the interpretations was actually initiated by the Court of Final Appeal itself, and it's written into the relevant article, which is Article 158. And in that particular article, it provides the various processes in which an interpretation may or may not be made. And one of these situations is when that it deals with matters that goes beyond the autonomy of Hong Kong. And in that situation, the Court of Final Appeal itself considers that it was an appropriate case to make the reference to the Standing Committee of the National People's Congress. But of course, one needs to look at the context of each of the cases where the interpretation needs to be considered. And there is another important thing we need to be very careful about when we talk about what we may call a freestanding interpretation, or an interpretation that is actually referred to by the Court of Final Appeal to the Standing Committee. As I think Sir Anthony Mason has made it absolutely clear, interpretation and adjudication are two very different concepts. And when the National People's Congress gives an interpretation whether when it's doing it on a freestanding situation or in a referral by the court, it is an interpretation of the meaning of the provision. And the actual application of the meaning of the provision will still have to be done by the courts if people wish to resolve it through litigation. And that, in effect, is written into the law, and it is, in fact, we believe, an materialization of the concept of the rule of law when it is actually written into the Basic Law itself, how these legal issues are to be resolved. And so when there is an issue as to the interpretation, that rests ultimately with the National People's Congress Standing Committee, and that is for the courts then to apply the interpretation for the adjudication of cases when the party seeks to resolve it through litigation. And I don't see a conflict over there. And I think when this happens, and when the body of jurisprudence becomes more mature, as we can see from the judgments that are recent and principled and are made available to the whole world to see, then people will begin to better understand how this is going to work and when an interpretation is necessary for the resolution of any dispute over the manner in which a basic law provision will have to be interpreted.
You know, as I looked at the Court of Final Appeal, it's a very reputable court. The judgments are cited outside the jurisdiction very frequently. There's one dimension, I think, on which the Supreme People's Court of the People's Republic of China is superior. And that actually has to do with inclusion and representation, because I noticed there's no women on the Court of Final Appeal and never have been. And I wonder if you could just say a little bit about gender in the Hong Kong judiciary. I know it's outside your portfolio, but you can tell us a little bit about that.
Yes. First of all, I wish to mention something about the Court of Final Appeal, which is our highest court. And like all other judges in the Hong Kong judiciary system, the appointment of judges are made through a Judicial Services Recommendation Commission, which involves the Chief Justice as chairman, the Secretary for Justice as an ex officio member, and it involves the Bar Association, Law Society, and also non-legal members from the community to sit on it, to make sure that people are appointed on merits. But going to the broader question of gender representation in Hong Kong, it is interesting that the worry, so to speak, should be the other way around. In our law schools, I think there is about 70% women and 30% men. And probably the boys are not doing as good as the girls. So I think as time passes, we would expect more and more lawyers who are women. And in fact, 2 years ago, when I was asked to officiate an event of the Hong Kong Women Lawyers Association, I did a check. In the Department of Justice itself, we have already got more women than men. And at that stage, we still got more men at directorate level than women. And when I checked the same figures last week, I just found out that at directorate level, we have more women than men. We've got 40 women and 39 men. So I think given as a matter of time, we would get more women rising through the ranks. We have actually got Court of Appeal judges who are women. We got 3 of them out of 12. And we've got our first Secretary for Justice who's woman. And currently we've got the Chief Executive who's a woman. And I think Hong Kong is doing well. The other thing I wish to stress is that equality before the law is something written into the Basic Law. And it's further implemented by a number of anti-discrimination ordinances in our domestic legislative framework, and that includes the Sex Discrimination Ordinance. And we have also had an Equal Opportunities Commission, which looks into these matters, And a number of years ago, we actually got a case. I hope I have the time to elaborate a little bit about that. We have a case where parents of girls went to court, took the government to court, arguing that it was unfair to allocate secondary school places to boys who are not doing just as good as the girls. And they won. They won for the reason, it's a very interesting reason. The government resisted the judicial review on the basis that boys mature only at a later age. And it is important to help the boys a bit on secondary school allocation. In court, the government lost the case. The judge gave the very simple reason that if you look at the whole process, the boys didn't do good enough anyway, even at university level. So there is little point helping them. In the end, the government didn't appeal. So we follow what the Equal Opportunity Commission says is the right thing to do. And since then, we allocate secondary school places in a manner which the court says it should be. So I think as a matter of time, we would see more women judges. And our last bar chairman is a lady. She's senior counsel. So we'll see the future having more women than men, probably, because we see more women law students than boys who are students for a substantial period of time.
I think that's a wonderful note to end our conversation. Let's hope that that comes to pass. Thank you so much, Solicitor General Wong.
Thanks.